ladies and gentlemen, members du Parlement. When I was asked to talk about Equitas, I had to, as a trained lawyer, I had to go back to the file and read the decision and see what it means. And of course, that required hours upon hours of reading and taking me into many, many areas. And my aim this morning, this evening, I should say, is to give you the essence of it. Now, how many of you have seen the statement of claim? Okay. How many have seen the decision by the BC Superior Court? Okay. What is Equitas? Equitas is a national non-partisan organization formed to support injured Canadian Forces soldiers suffering from long-term disability. The claim has been filed in the British Columbia Supreme Court by a law firm called Miller Thompson in Vancouver, and it's a class action suit, and it names 5 individuals. They're the one who are going to be the face of the lawsuit so far, and others will be asked to join in as the suit progresses through the trial system. There is a system, a statement of claim. The statement of claim is something like 350 some odd paragraphs. It goes on for pages. It covers the waterfront plus some. It presents a very powerful case, and I highlight some of them. It is not surprising. It's something which I see in practice most of the time. When we sue the federal crown, if there is a possible way that the Crown can move quickly to have the claim dismissed, they will do so, and they're quite good at it. 50% of the claims that are challenged by the Justice Department eventually end up being dismissed. So we should see this decision by the Supreme Court of British Columbia as significant. If you had asked me a number of months ago, when I read the claim, extensive as it is, provocative as it is, and really going into areas where the law hasn't been settled, I would have said, I'm not a betting man, but I would have said that will be dismissed. And that's exactly what the Justice Department did. But the court thought otherwise. It allowed the claim to survive. And what does it mean? It means, as a minimum, that the Justice Department will have to file a statement of defense to address each one of the allegations and present their positions instead. That's what normally happens. What has happened in this case is another option which the Justice Department has, and that is it can appeal this particular decision, and that's what it has done. The decision came out on the 6th of September. On the 3rd of October, the Justice Department, speaking for the Attorney General, has filed an appeal. So that's going to go to the British Columbia Court of Appeal, and we'll have to wait probably a year or more before we have a decision on it. I'm not a betting man, but it doesn't really matter which way the decision goes to the Court of Appeal. That's going to make its way to the Supreme Court. Not on the substance of the claim, but whether or not veterans, at least this class action, should be allowed to proceed. And if the Supreme Court were to say yes, because I'm convinced eventually this is something they will have to do, then they will be held to pay. Because the challenge is significant. The challenge goes to our bones, goes to our structure, goes to our raison d'etre, goes to the nature of what the Crown is and what the honor of the Crown is. What was the claim? Let me give you the highlights. The first claim is that injured veterans are entitled to claim benefits, assistance, and compensation under federal legislation. It should be an accepted fact, but it ain't. At the moment, we have 2 pieces of legislation that provide such benefits and assistance. The Pension Act and the Canadian Forces Members and Veterans Re-establishment and Compensation Act, otherwise known as the Veteran Charter. And it's precisely because the Charter has established a lump sum payment as a way to compensate a veteran, an injured veteran, and his family for the rest of his life that this lawsuit has seen today. In the claim, very clear, and I will read you the language because I couldn't prove it. The named individual who are suing complained that a compensation provided under the provisions of the Charter is arbitrary, substandard, and inadequate for supporting themselves and their families. They say that their compensation and other benefits have been substantially reduced from what was formerly granted under the provision of the Pension Act. Some of you in here probably would acknowledge that as being factual, but that's the essence of the claim. And it goes on. Moreover, the claimant says, they are being treated unequally because the benefits and compensation available under the Charter are substantially less favorable than those that are available to injured person claiming under tort law or worker compensation law. I have a case in the office, exactly that, where we're suing the Workmen Compensation of Ontario, and the benefits which will be accrued to this particular person who got injured in Afghanistan as a civilian are about 10 times as much on a monthly basis that a veteran gets. The claimants said 3 fundamental things. First of all, there is a social covenant in our society to support veterans. And this existence of the social covenant gave rise to a fiduciary duty on the part of the Crown to be looking after veterans and their families. Let me say a few words about a social covenant. And I'm reading from the statement of claim. When members of the Canadian Forces put on the uniform of their country, they make an extraordinary personal commitment to place the welfare of others ahead of their own personal interests, to serve Canada before self, and to put themselves at risk as required in the interest of the nation. A veteran, whether regular or reserve, active or retired, is someone who, at one point in their life, wrote a blank check made payable to the Government of Canada for an amount of up to and including their life. The commitment to make the ultimate sacrifice reflects their honor in the service of their country. This is what the 5 veterans said, and this is what Miller Thompson presented to the court, and this is what the judge had to sit and considered. The claim goes on to say there is no equivalent profession to that service in the Canadian Forces. Because of this extraordinary commitment, there is a long recognized covenant that exists between the Canadian nation, the nation's people, and those who hazard their life in the service as members of the armed forces. Members of the Canadian Forces are entitled to expect that if they sustain illness or injuries in the line of duty, they will be taken care of by the country they served. If the Canadian Forces is to retain and reinforce the loyalty and commitment of its members and attract new recruits, Canadian Forces policy must strive to ensure that such expectations are met. A sidebar, important one. Many of the class members enlisted in the Canadian Forces at the time when the Pension Act governed their compensation for injuries and disability. They later found out, as a result of their service in Afghanistan particularly, that there is now a new actor, a new set of regulation, new set of statute that effectively reduces their benefit. The second major argument that is being used in the claim is what is referred to as the honor of the Crown. It's a doctrine that said it would be a breach of public duty if their rights were not to be provided from a fiduciary standpoint from the nation. The honour of the Crown doctrine refers to the principle that servants of the Crown must conduct themselves on honours when acting on behalf of the sovereign. That's what Sean refers to as the bureaucrats at Veterans Affairs, ND&D, and our parliamentarians and legislators. They have a duty to uphold the honour of the Crown when drafting legislation or applying legislation and when addressing the needs of our veterans. What is significant here is the honour of the Crown doctrine has never been used up until this time for anything but the Aboriginal claims. First time we strayed outside, and Miller Thompson, the statement of claim, makes a very powerful, a very important argument that the same honour is owed to the veterans, not only to the Aboriginals. And under the honours of the Crown doctrine, the claim goes on saying, members of the Canadian Forces bear a unique relationship with the Crown insofar as they are required by law to face injury or death, to carry out the orders of the military commanders in furtherance of the policy determined by the Government of Canada. Casualties are anticipated and planned for by superior officers. Canadian Forces members are given no choices. They must obey the orders of their superior to go into battle or face severe military sanction. The claim also goes on to say that until 1998, when the National Defence Act was amended, the death penalty existed for several military offences, such as showing cowardice before the enemy. Powerful language. Statement of claim then goes on and talk about fiduciary duty, and I'll be very short because it goes on even in more detail and in more depth as to the requirement to address that and to be cloaked with that responsibility. I'm reading from a statement of claim. The fiduciary duty arises from the honour of the Crown. It requires the Crown to keep the promises that Canada has made in the social covenant and the social contract with those who served. It says the government knew or ought to have known that the class members, as all the veterans that would eventually come under the umbrella of the claim, were relying upon the government to care for them, to protect their rights and entitlement to the service and benefits required by Canada when they served the Canadian Forces and the honour of the Crown, and they acted in the government's best interests. Justice Witherill, who was the presiding justice in his decisions, which goes on for 49 pages, is careful to couch on paper all of the arguments presented by both parties, more significantly, of course, by the veterans. Reason is, the veterans did submit their claim, and the Crown had yet to address the claim, had yet to present a statement of defence. Some of the comments which I will, and I'm cherry picking in here to try to give you an essence of where each